Good morning, everyone. My name is Ghandi Badela. I am a practicing advocate and an alternative dispute resolution practitioner in South Africa. I am also a director of the Arbitration Foundation of Southern Africa. I am honored today to moderate this webinar session. First, I would like to welcome you all. It is indeed a great pleasure to both have the panelists and friends and colleagues from Indonesia. Although we are geographically situated in the opposite ends of the world, we share the same objectives and ideals. I am grateful today to take this opportunity to introduce the Arbitration Foundation of South Africa, and in particular, to introduce the International Division of the Arbitration Foundation of South Africa. We have together today a panelist that will take us through the rules of the International Arbitration Foundation of South Africa. I'm also honored and proud to inform you that AFSA is rated as a top arbitration center in Africa, according to a survey that was conducted by the University of London and the School of Oriental Studies. I urge you and invite you to visit the website of the Arbitration Foundation of South Africa so that you can learn more about us and what we do. At this moment, I would like to take this opportunity to briefly introduce the panel that we are going to be having. Today, we are honored that we are going to be addressed by Advocate Patrick Lane SC. We will also be, who heads the International Arbitration Department of AFSA. We will also be addressed by Advocate Kuper SC, who is the chairperson of the Arbitration Foundation of Southern Africa. We will also hear from Des Williams, who chairs the AFSA SADC division. Thereafter, we will be hearing from Jonathan Ripley-Evans, who will address us on the AFSA international rules, followed by Svetlana Vasileva, who is the Secretary General of the International Arbitration Department. Thereafter, we'll hear from Roger Wakefield, who has over 30 years experience and who is working with Berksman attorneys. Colleagues, we indeed are honored to have the panel that we have, and are also honored to be hearing from our guests and our friends from Indonesia, who will also address us on their board. Without wasting any more time, I would like to ask Mr. Patrick Lane to address us on. Thank you.
Yes, Ghandi, thank you very much, and good morning, everybody, and thank you for joining us. AFSA, the Arbitration Foundation of South Africa. I want to trace, it has a long history which goes way earlier than the introduction of the new International Act in South Africa. But for the time being, I want to concentrate upon the International Committee of AFSA, and in particular, to give you a broad outline of what it has achieved and how it operates. The new International Act was passed in December 2017 in anticipation of the new legislation, which is largely based upon ancestral model law. It set about drafting a new set of international rules. You'll hear more about those international rules from Jonathan Ripley-Evans when he speaks to you. The international division, of course, doesn't derogate from its multifaceted function in the domestic market. But since December 2017 and the inauguration of the new rules, there have been over 130 international cases which have been referred to AFSA to administer. The rules themselves, you will hear, are cutting-edge rules, and for the first time introduced the International Court. This is now the AFSA Court. The AFSA Court consists of members from the United Kingdom, from France, from Germany, from Australia, from China, from Botswana, from Ghana, and from South Africa. And they sit at the head of, if I can put it that way, the AFSA International Division, in the sense that all major decisions are made by the International Court, including the appointment of arbitrators, the challenged arbitrators, etc. I had a rider when I said to the challenged arbitrators, the jurisdiction, competence is also enjoyed by the tribunals, which are appointed by AFSA. Just looking at the panelists, and I will talk a bit later about the nature of the panelists and the qualification to become panelists. We have developed, again since 2017, an international worldwide set of panelists who have qualified, and the membership, again, I'm not going to spell each country out, but the membership and panelists come from 30 different countries. Neutrality is obviously a significant feature of the international arbitrations conducted under the auspices of AFSA. The mechanism for the referral disputes, the appointment to the panel, will find amongst those who are used to international arbitration, you will find a comfort zone. Even though the rules may differ to some extent, and they are at the cutting edge, there's nevertheless a comfort zone which you will find, which is similar to other international organizations. The other feature is that it is fully equipped to deal with international arbitrations remotely or partially remotely, and in addition has, again, cutting-edge facilities within AFSA itself for the holding of hearings in person. I think what one should now do is to pass to other speakers who will deal more fully with the rules and the significance of the rules and what has been developed by AFSA International since 2017. So let me leave the introduction at that point in time.
Thank you very much, Pat, for that introduction. And what I would like now to do is to give this opportunity to Mr. Kuper to introduce AFSA.
From the pressure and not able to address you. I'm Michael Kuper. The as a institution, some statistics and some important information if one wants to understand the general context in which AFSA works and in which particularly the international division of AFSA operates. AFSA was established in 1996. And it was established as a non-profit organization, and its members came from the leadership of the legal profession in South Africa. And in South Africa, the legal profession is divided between the attorneys or solicitors and the advocates or barristers. And both parts of the legal profession came together with other stakeholders who were interested in creating and establishing an arbitration institution in South Africa. They came from the leading accounting firms of the country and from business stakeholders, as well as interested parties from the construction industry. And they constitute the founding membership of the Arbitration Foundation. And today there are 30 such firms, bars, and institutions who make up its membership. Of those, two of our founding members are based in the United Kingdom. One is based in the United States, but the bulk of the others, insofar as they are legal firms, are all of an international caliber. The idea of AFSA was that it would bring to South Africa administered arbitration in the form in which it is internationally known, and would in addition undertake the functions of training, would undertake the function of domestic arbitration in all its various forms, would encourage and introduce mediation and all the various conciliatory aspects of dispute resolution. And that over the years is what AFSA has done. It is self-funding. It does not rely on government, nor does it rely on any sponsor for its funds. It is responsible itself to pay its way. And that has given AFSA an independence, which is certainly within the African continent, a very necessary feature in an arbitration institution. As it grew and as it established itself, AFSA broke into various divisions, each division having a particular responsibility for an aspect of dispute resolution. And thus we have a division whose function it is to oversee domestic arbitration in this country. And at any one stage in the head office of AFSA, there will be something between 300 and 400 current commercial disputes which are administered from head office, and others that are being administered through branches throughout the country. We have branches in all the important commercial centres of South Africa, in Cape Town, in Durban, in Pretoria, and along the Eastern Province and the Garden Route. We're therefore able to offer our services throughout South Africa, and we have been proud to do so now for a number of years. In the domestic field, AFSA introduced administered arbitration and brought the profession in line with practice around the globe in the training and in the administration of domestic disputes. AFSA has become important to the government in certain areas. So, for example, in our Banks Act, which regulates the activities of all commercial banks in the country, AFSA is the appointed arbitrating authority in the event of a dispute between the government financial regulators and any particular bank and the directors of any particular bank. AFSA discharges that duty with an independence which comes with being financially self-sufficient. And so it is in labor, in mediation, and then if I can just touch on the SADC division, to which my colleague Des Williams, who heads that division, will talk to you in a few moments. AFSA was never created to operate in South Africa alone. It was created to operate in Southern Africa, in the 16 countries which make up the region of Southern Africa. And in that capacity, its job is to harmonize and standardize into international and regional arbitration in those 16 countries. And therefore, when today we speak to you of AFSA in its regional capacity and in its international capacity, we speak to you as an organization that is dedicated to bringing Southern Africa into the global spotlight as a competent and welcoming venue for international and regional arbitration. I hope very much that AFSA will also enjoy the support and the guidance and the collegial cooperation with Indonesia, just as we enjoy it with China and with the BRICS countries and with many of the leading global arbitration centers. Thank you very much.
Perhaps I would ask Mr. Kuper to touch on KJAC a little bit, because I understand that AFSA is also involved already in an initiative with Asia. Thank you.
Yes, indeed. In 2013, AFSA was approached by the China Law Society to build relationships with leading arbitration institutions in China as part of the resurrection of the Silk Road and the Silk Road between China and Africa. And the Arbitration Foundation committed itself to make its contribution in that regard. And after interchanges with the leading arbitration institutions in China, we formed a partnership, initially with the Shanghai International Arbitration Center, but thereafter with the Beijing International Arbitration Center and the Shenzhen Court of Arbitration, and in Africa with our colleagues in Kenya and our colleagues in Ohio in West Africa. The object of which is to provide a united platform, to provide a united panel of arbitrators, to provide united rules, to deal with disputes that might arise, whether commercial or investment, between businesses in China and in Africa. There is a rotating chairmanship of KJAC, and this year the constitution and the rules of KJAC were finalized and adopted by all the participating parties. I look to KJAC as constituting a bridge, and an important bridge, between Africa and Asia, between Southern Africa and China, in the furtherance of dispute resolution.
And thank you for that. I really appreciate it. And also, by the way, I might add that AFSA is also involved in BRICS initiative, where it is also seeking to establish itself as a center that will be able to resolve disputes that arise in that regard. With that the rich history, I think it becomes more important to say, to have a closer look at the AFSA International rules. And for that, I'm going to request Jonathan Ripley-Evans to address us in this regard. Thank you. Jonathan, to you.
Thank you very much, Ghandi. Good morning, everyone. Thank you very much, Michael and Patrick, for very helpful background to the rules, because it's quite important to understand why AFSA embarked upon this process of having a look at a dedicated set of international rules. We know that South Africa came from a different history to what we are facing at the moment, and it was largely due to the 2017 International Arbitration Act, which changed a number of fundamental things for international arbitration in South Africa. Most notably, we now had enforced institutional model law, which really opened the doors for AFSA to really take advantage of developments around the world. And it was an opportunity for AFSA to align its rules with what was expected from the international community more broadly. And it was also the right time for AFSA to look at certain innovations and changes to the way that it operates and administers its arbitrations in accordance with its rules. So against that background, I'm going to do a little bit of a whistle-stop tour through some of the provisions which might be interesting. From a South African perspective, a number of these provisions are quite unique and change the way that we were used to administering our arbitrations. From an international perspective, none of these provisions are particularly unique. Some of them are more innovative than others, but the whole purpose of the drafting exercise was to present a set of rules that looked familiar to practitioners across the globe, all in an effort to make AFSA arbitrations more attractive and accessible to practitioners in all corners of the globe. I won't spend much time on the drafting process, but what I will say is that the process was quite a comprehensive process of collaboration and cooperation with the community across the globe. We consulted extensively with practitioners leading their fields and ended up with a set of rules that we as AFSA are incredibly proud of. And I think we will start at one of the bigger changes that the rules brought about for AFSA and for arbitration in South Africa, and that was the establishment of the AFSA court. Now, prior to this, we haven't had any established court linked to an arbitral institution. And the main reason why AFSA decided to introduce the court was to separate the decision-making functions of AFSA from the administrative functions of AFSA. A lot of this is to further transparency and trust in the institution. So Article 2 of the new rules deals with the AFSA court. The next thing I want to touch on is just the presumption in the preamble to the international rules. Now, these rules have been drafted with the intention of an increased support for the rules moving forward. And one day we hope that we will sit with one set of AFSA rules that will apply across the board. We're not there yet, and so the domestic rules still apply for domestic matters. But we are trying to encourage people to adopt the international rules to standardize the practice in domestic arbitrations in South Africa with that which is expected globally. If we move on to Article 10 of the new rules, we'll see provisions that provide for expedited procedures. This was quite a necessary provision for the rules, and we took the decision that we didn't want a separate set of rules as an independent document governing expedited procedures. So Article 10 then deals with this provision. And the first thing worth noticing is that expedited procedures are available prior to the constitution of the tribunal and for amounts below $500,000 or where the parties agree to apply the expedited procedures. Now, the figure that we arrived at in putting together these rules was a figure that had to be attractive or appropriate to the domestic market as well as for the international market. Now, in some jurisdictions, an amount of $500,000 is particularly low, and we received a lot of feedback on that point. But the reality was that we needed to provide something that was accessible and attractive to the domestic market. When I say domestic market, we're talking about the SADC region. And so if the amount is higher than 500,000, the parties are free to agree to apply the expedited procedure. With the application of that procedure, we have the power of the Secretariat to abbreviate time periods and the appointment of an arbitrator by the court. And this was a little bit controversial, but was largely supported, notwithstanding the provisions of the arbitral agreement. So in terms of this provision, the AFSA does not then have to go through a lengthy process. If there is a big debate between the parties on the appointment, it has the power to appoint an arbitrator for purposes of expedited procedures. Also, the reasons may be handed down in summary form, and a final award needs to be handed down in 6 months. So we believe that that is quite a positive development in terms of arbitral rules, and we're hoping that it will grow in popularity. Article 11 provides for the appointment of an emergency arbitrator. Now, this is something that is no longer new in the international context. The provisions there are relatively standard when compared to other international institutions for the appointment of an emergency arbitrator. But we think that this is quite important, particularly when we're dealing with the provisions under the International Arbitration Act and the common law in South Africa relating to interim relief approaching courts at certain stages. Now the parties really do have an alternative, being the emergency arbitrator. One of the more controversial provisions in Article 12 dealt with the early dismissal of claims. And this is something that came out of the extensive consultation process. There's a growing need to address the prevalence of unmeritorious claims. And a few institutions around the world have started introducing provisions for early dismissal. We should say that it still is the exception to the rule because it is relatively drastic. And it is only in the clearest of cases where the claims are manifestly without merit or clearly outside the jurisdiction of the tribunal that such claims may stand to be dismissed on early or an earlier stage. So that is Article 12. Article 23 deals with the appointment of tribunal experts. This is also a new development. And this is simply the power of the tribunal to appoint a neutral expert to assist it in its deliberation. We believe will be incredibly helpful moving forward, and now it is provided for in the rules. Interim measures are dealt with in Article 24, and I will not talk about those because Des is going to be talking about them very soon. But we also think incredibly important and will grow in popularity and uptake very soon. Article 25 deals with security for costs, a very necessary provision in the rules. Again, one of the more more difficult provisions to convince the tribunal to award security for costs, but extremely necessary, particularly when you're dealing with developing nations and developed nations. There is always a concern about costs. So Article 25 deals with the provision of security for those costs. Flowing then from that, there is a provision in Article 27 dealing with third-party funding. Now, this also came out of the extensive period of public consultation and followed on from the recommendations coming out of the ICA Queen Mary study on third-party funding. AFSA acknowledges that third-party funding is clearly will play a big role in the future of international arbitration, particularly on the continent. But what AFSA did when incorporating these provisions is it acknowledged the detailed research done by the Queen Mary study and has only included provisions relating to the existence of third-party funding and the name of the funder. And the reason for that is for conflicts of interest. The only reason why we're putting this in there is because third-party funding is becoming so prevalent. The opportunity or chance of conflicts arising is growing on a daily basis. Those provisions are not there to try and induce parties to bring applications for security for costs, because we are seeing more and more in practice that the existence of third-party funding does not necessarily mean that a party does not have the funds. More common these days, parties are turning to third-party funders purely in an effort to manage their balance sheet. And so it is a conflict of interest provision, but we thought that it was incredibly important to have that in the rules itself. Article 28 then deals with multiple contracts and provides for the consolidation of arbitrations. 29 deals with joinder and intervention of similar nature. I should also mention that joinder, intervention, and consolidation are provisions which you will find in the leading institutional rules around the world, and they are not too controversial, but they are incredibly necessary, particularly, for example, in construction disputes where you often have linked contracts. It's important to be able to join the right people, for the right people to intervene and to consolidate proceedings from an efficiency perspective. Article 36 is quite an important provision, and that deals with confidentiality and publication. And the starting point, as you would expect in rules of this nature, that all deliberations and the award itself remains confidential to the parties. But there was a very important provision included in Article 36. And whilst AFSA has not acted upon this yet, we do believe that it will be necessary in the future. And this is the right of AFSA to publish anonymized awards unless the parties object thereto within 30 days of the issuing of the award. Now, that's incredibly important from a growing jurisdictional perspective. More and more, there is a need to share the knowledge and the learnings that we are assisting grow the legal system in South Africa and Southern Africa to grow. We want to share these with practitioners and users of arbitration in the region. And the confidentiality provisions would generally stifle that. And so we see that this is also a provision that is gaining in popularity in rules around the world at the moment. The parties still have the right to object. It will only be published in an anonymized form, but we encourage parties to agree to the publication of the awards. And the intention is ultimately for AFSA to start publishing select awards to assist with the development of arbitration in the region. Article 26.4 also then deals with general party guidelines, and we also thought that this is quite an important provision, given that it's gaining a lot of international attention these days. And this simply sets forward the guidelines for representatives in international arbitration and is aligned with institutions across the globe. Those, in a nutshell, are the key characteristics of the international rules. There are a number of provisions that may or may not be different to the rules that you may be familiar with. But from a South African perspective, we believe that those are the ones that are unique from a domestic perspective, but certainly align the rules with international best practice. And you may have noticed that the rules themselves are what may be termed light touch rules. AFSA is largely a light touch institution. It is not like the ICC that will take an active role in the actual administration or the scrutinization of awards. AFSA has taken one step back slightly to give the power to the tribunal, and whilst it will have oversight and will administer properly, it does not necessarily want to interfere with the process, and that essentially is the characteristic of the rules. And on that note, I think there's a Q&A session a bit later if there are any questions, but I'll hand back to Ghandi.
Thank you very much for that, Jonathan. It was really a summary of the key features of the international rules as they are today. And having heard the background, some key features of the rules, I think now I'd like to call upon the Secretary General of AFSA International to give a summary, a brief summary of the administration process. To you, Ms. Vasileva.
Good morning, afternoon, and evening, everyone. As Secretary General of AFSA International and Registrar of AFSA SADC and KJIC, I'm honored to stand before you today and walk you through the full spectrum of AFSA arbitration process. This will encompass the initial steps of triggering arbitration proceedings, the key phases of arbitrator appointment, the nuances of cost, and the delivery of the awards. As we will delve into the technical complexities and practical consideration that underpin the 2021 revised AFSA international rules. For expedience, as can we agree that you take notes during the presentation and we can discuss them after I complete my presentation. Introduction. AFSA is the leading arbitration institution in Africa that administers disputes resolution with the primary focus in arbitration. AFSA International is a division of AFSA that administers all cross-border disputes. AFSA International Rules 2021 are applicable to international disputes and are based on the ancestral arbitration rule, but with various amendments reflecting the international best practices. Where parties have agreed that their dispute will be administered by AFSA and the arbitration is international, AFSA international rules will apply. Key stages of AFSA arbitration process. There are 7 key stages of AFSA arbitration process, starting with commencement of arbitration, answer the award and any counterclaim, appointment of arbitrators and related, case management conference, written statement, conduct of the proceeding, and issuing the awards. Next, we will delve into the details of the stages highlighted in bold. Commencement of arbitration. The initiation of arbitration proceedings take place when the claimant submits a request for arbitration to the AFSA Secretariat. This request can be submitted in a digital form with the commencement date being the date the Secretariat received the request, providing that AFSA received the registration fee. In order for arbitration to be registered, the claimant is obliged to dispatch a copy of the request to all parties simultaneously and submit proof of delivery to the Secretariat. The appointment of arbitrators. According to AFSA rules, a sole arbitrator will typically be appointed unless the case complexity or the agreement between the parties suggests otherwise. This appointed arbitrator must then be confirmed by the Secretary General. If party agreed to the nomination, they can propose the arbitrator to the Secretary General for confirmation. But if there is no agreement within 30 days or other agreed time frame, the AFSA court will take charge of the appointment. When the 3 arbitrators need to be appointed, each party nominates 1 co-arbitrator, and these co-arbitrators then nominate the presiding arbitrator. The appointment of the 3rd arbitrator, who will serve as the presiding arbitrator. Please, the next slide. Who will serve as the presiding arbitrator is typically done by the court unless the party have agreed on another procedures. However, the nominated arbitrators must still be confirmed by the Secretary General. If the party agreed procedures does not result in nomination within 30 days of the appointment of the co-arbitrators or within any other set timeline, the court will take over the appointment. For disputes involving multiple parties, the claimant and the respondent must jointly nominate the arbitrator. Emergency arbitrator. The rule. Next slide, please.
Last slide. Next one.
Emergency arbitrator, yes. Next slide. The rule will enable parties to apply for immediate interim relief. Such an application can be made before, alongside, or after filing the request, but must be before the tribunal formation. If the Secretary General approved the application for emergency measures, the court will appoint an emergency arbitrator within 2 days of receiving the application with the associated fees. The emergency arbitrator is responsible for determining the claim for the emergency measures as quickly as possible, but not more than 14 days after its appointment. Finally, any decision made by the emergency arbitrator can be confirmed, varied, dismissed, or revoked in whole or in part by the tribunal once it's constituted upon upon application by any party or initiated by the tribunal itself. Challenge or removal of the arbitrators. Arbitrators are subject to challenge for 15 days if there are justifiable doubts. If the challenge arbitrator does not step down voluntarily after the challenge or the opposing party agrees to the challenge within 15 days of receiving the written statement, then the court will make the decision on the challenge. The court has the authority to determine the appropriate fees and expense for the service rendered for the former arbitrator. Furthermore, the court also has the power to remove the arbitrator on its own initiative. Replacement of an arbitrator. Should an arbitrator step down, pass away, withdraw, or be removed, a substitute will be assigned according to the same procedures that guide the appointment of the replaced arbitrator. The arbitration process resumes from where the replaced arbitrator left off unless the tribunal determined otherwise. Under extraordinary circumstances, the court can permit the remaining arbitrator to proceed with the arbitration. Cost of arbitration. There are specific stipulations regarding how cost-related arbitration proceedings are allocated and distributed, as well as rules concerning security of cost and deposit. These are outlined in Articles 25, 32, and 35 of AFSA International rules. The fee schedule for AFSA arbitration is detailed in particular in Annex 3, registration and administration fee. The AFSA International rules prescribes that claimants should pay registration fee of $345 when submitting their request for arbitration. This payment is not refundable. As for administration fee, they are determined on the sliding scale based on the claimed value. In addition to the standard administration fee, which follows Schedule 3, the Secretariat may levy additional charges to cover any other reasonable and actual expenses incurred during the arbitration proceedings. Arbitration and legal cost. Arbitration costs encompass arbitrators' fee and expenses, the cost incurred by the administrative secretary and AFSA in line of cost schedule, the fee of any expert appointed by the tribunal, as well as other costs associated with the tribunal reasonable request for assistance. All parties involved are jointly and severally accountable to AFSA and the tribunal for this arbitration cost. Legal costs refer to any legal or other related expenses a party incurs during the arbitration process. When deciding on arbitration and legal costs, the tribunal generally bases its decision on the parties' relative success or failure in the award, except where it appears to the tribunal that, in the given circumstances, the application of such a general principle would be inappropriate under arbitration agreement or otherwise. Security of cost. Under particular circumstances, the tribunal might require a party to supply security of cost. If a party fails to comply, the tribunal retains the authority to stay or dismiss the party claim, either entirely or partially. Such a decision is formalized through the order or the award. Deposits. The Secretariat has the authority to direct parties to continue towards the arbitration costs, which are retained by AFSA. Any remaining funds will be refunded to the parties at the arbitration conclusion. In case a party declines or fails to make a payment, the Secretariat can request the other party to substitute this payment. The party that covers the payment can subsequently seek the tribunal's order for defaulting party to repay the sum immediately, along with the applicable interest. If a party initiating a claim fails to fulfill the payment related to the arbitration cost, after consultation with the tribunal, the Secretariat might instruct the tribunal to hold its proceeding and set deadline upon whose expiration the relevant claim or counterclaim will be deemed withdrawn. Issuance of the award. When the tribunal consists of multiple arbitrators, an award is granted based on a majority vote. If there is no majority, the presiding arbitrator makes the decision. If parties settle prior to the issuance of the final award, the tribunal might either issue an order ending the proceeding or document the settlement in the consent award, if requested by the parties and if the tribunal does not object. Such an award does not necessitate the reasoning. The tribunal possesses also the authority to correct clerical or typographical mistake or provide an interpretation of the award within 30 days on its publication. A party has the right to request also an additional award for the claim submitted, but not covered in the award within 30 days of its receipt. The tribunal can deliver the additional award within 60 days of receiving the request. Correction, interpretation, or additional awards are considered an integral part of the final award and follow the same requirements. The arbitral awards under AFSA International rules are final and binding. The involved parties agree from inception to immediately execute the award and waive their right to any recourse or appeal. Key takeaways. Here, I attempt to provide a summary of the 13 points of my presentation. Closing remarks. We appreciate your time and attention today and hope this presentation has provided a clear understanding of arbitration under AFSA International rules. Thank you once again for your participation. We remind at your disposal for any further clarification. I will now open the floor for questions if you might have.
Okay. No, we will take the questions at the end of the session of the presentations. I think thank you very much for that summary of the administration work that you do. And I think at this point in time, I would like to call upon Des Williams to give us a brief view on the measures that are available in arbitration that with respect to the arbitration system. Thank you.
Thank you very much, Ghandi, and there we go. Forgot about the switch. Thank you very much, Ghandi, and good afternoon to everyone in Indonesia. It's a great pleasure to be able to discuss this topic of interim relief with you this afternoon or this morning here in South Africa. Previous speakers have already drawn your attention to the fact that it was only in 2017 that South Africa stepped into the modern world of international arbitration by enacting an International Arbitration Act, which provided for the adoption of the UNCITRAL model law. Ryan, have you got the slides? Yeah. If we can, I just don't see what slides are. The next slide. And now to the next one. The adoption of the model law was subject to the provisions of the International Arbitration Act of 2017. This resulted in some revisions to the model law, the most important of which, for the purpose of the discussion today, was in Chapter 4A, which deals with interim measures. South Africa followed the approach taken by Mauritius and Australia in rejecting Articles 17B and C of the model law. This is an approach which upholds the right of the parties to equal treatment and due process, and also recognises that effective ex parte relief can only be obtained from the court. This is an issue in the model law that has been fairly controversial over the years, and different countries have taken different positions. Brian, next slide. Against this background, let me take you firstly to Chapter 4 of the model law as adopted by South Africa. You will Brian, sorry, that's the previous slide. Chapter 4 of the model law is adopted by South Africa, and you will see just with the headings there from the different provisions, you will see that what's happened is that Article 17, which deals with the power of tribunals to order interim measures, and 17A, conditions for granting interim measures, those remain in the South African version. However, Articles 17B and C have been removed. They are omitted from the South African version. And it then goes on to the remaining provisions, which is modification, suspension and termination, security, disclosure, costs and damages. Now, what happened here in reaching its conclusion that Articles 17B and C should be rejected, the South African Law Reform Commission referred to the views of Gary Bourne, who will be very well known to all of us, who makes two main arguments against these provisions. The first is that unilateral communications between the tribunal and one party only, which preliminary ex parte orders entail, undermine the equal treatment of parties and due process entrenched in the model law. The second, more fundamental objection is that preliminary orders provided for by B and C have no direct coercive effect and therefore cannot accomplish the purpose of ex parte relief. The Commission also supported the view that the tribunal's power to grant ex parte interim measures is incompatible with the consensual nature of arbitration and proper respect of due process. The Commission therefore concluded that a party requiring ex parte relief should logically approach the court and not the tribunal. And so, next slide. When we turn to the AFSA International rules, we find Article 24. One slide, thanks. And you will see there that Article 24 refers in 24.2 refers specifically and provides that an interim measure is a temporary measure by which at any time prior to the issuance of the award, by which the dispute is finally decided, the tribunal orders a party, for example, and without limitation to, and then various examples are set out. It's the previous slide, Brian, just you can go back there a second. And then you'll find into that the specific examples of the type of relief that can be obtained are set out. And then if we move to the next slide, we've got 9 and 10, which provide that the power of the tribunal under Article 24.1 shall not prejudice the party's right to apply to any competent judicial authority for interim or conservatory measures prior to the constitution of the tribunal and in appropriate circumstances after the constitution of the tribunal. Presumably this includes ex parte applications for interim relief. 24.10 provides that a request for interim measures addressed by any party to a judicial authority shall not be deemed to be incompatible with the agreement to arbitrate or as a waiver of that agreement. And so in conclusion, to summarize the position, what we have in South Africa is interim relief measures are available in international arbitration seated in South Africa and administered by AFSA International, both under our Act and in terms of the AFSA International rules. Secondly, ex parte relief should be sought from the court and not from the tribunal. Thirdly, examples of the specific types of relief which may be obtained in an AFSA international arbitration are set out in Article 24(2) of the International Arbitration Act, the section that we looked at earlier. Thank you very much.
Thank you, Des. Thank you for that presentation. At this point in time, what I would like to do is to invite Roger Wakefield to address us on enforcement of AFSA awards. To you, Roger.
Thank you, Ghandi, and good morning, everyone. It's a great pleasure to be able to speak to you all and our colleagues and friends in Indonesia. So I'll be discussing the topic of enforcement of AFSA awards in Asia, and that includes Indonesia, with an emphasis on Indonesia, Southeast Asia, and beyond. And of course, as I say, this is in the context of the enforcement of an AFSA award. So let me start by saying that a court of a foreign country, which is party to the New York Convention, will see an AFSA award as emanating from a reputable arbitral institution of long standing. Effective administration and adherence to the AFSA rules gives rise to an arbitral award that is arguably less likely to be set aside. And this is in contrast to an ad hoc arbitration, or an award arising from an ad hoc arbitration, where procedural irregularities are more likely to occur in the absence of proper administration. So obtaining an AFSA award, of course, is only half the battle. It has to be enforced to be of any value. So I will be discussing this, as I say, in the context, enforcement of the award in the context of Asia, Southeast Asia, but a particular emphasis on Indonesia. But before I do that, I'll discuss the New York Convention on the recognition and enforcement of foreign arbitral awards, which applies to the majority of countries in the world. 80%, I think, of the countries on Earth, or in excess of that figure, are party to the New York Convention. Most Asian countries, including Indonesia, China, India, Singapore, have acceded to the convention with some reservations, but we'll see later what those reservations are and the impact of them. The convention was convened, I think it was in 1958, by the International Chamber of Commerce, and its prime purpose is to oblige contracting states to ensure that valid arbitration agreements are upheld and that foreign arbitral awards are enforced. An effect is given to the convention by each contracting state incorporating the treaty into its domestic law. It is also a feature of the UNCITRAL model law, and those countries which have adopted the UNCITRAL model law will have adopted the convention as part of that. And a number of Asian countries have based their arbitration laws on the model law, and these include Singapore and India. So as at January 2023, 172 countries have acceded to the convention, which has been described as the most successful international instrument in the field of arbitration, and more extravagantly, as the most effective instance of international legislation in the entire history of commercial law. So turning to the most important features of the convention, they are Article 2, which obliges courts, as I mentioned earlier, to uphold written arbitration agreements. And it follows that if a court is seized with a matter that should properly have been referred to arbitration, it is obliged to refer it to arbitration unless it is satisfied that the agreement is void. The other, well, it really is the crux of the convention, and they are the limited grounds on which a court may refuse to recognize and enforce the foreign arbitral award. And these grounds, of course, provide the very limited defenses to enforcement. And they are where the parties, so these are the grounds to refuse enforcement, it's where the parties to the arbitration agreement lack legal capacity, or where the agreement is invalid, or where the defendant was not given proper notice of the appointment of the arbitration of the arbitrator or of the proceedings themselves, or where a party was unable to present its case. It is also where an award deals with matters or issues beyond the arbitrator's jurisdiction or mandate, and where the composition of the tribunal or the proceedings themselves breach the arbitration agreement, and interestingly, where the award has not yet become binding on the parties or has been set aside or suspended by a competent authority in the country in which it was given. In this case, Article 6 empowers a court to stay the enforcement proceedings and to order the defendant to provide security for the claim pending the determination of the proceedings to set aside or suspend the award. I mentioned earlier the reservations. So countries are able to accede to the convention subject to two, at their election, subject to two reservations. The first one is reciprocity. And this reservation allows a contracting state to apply the convention only to awards emanating in the territory of another contracting state. And the second reservation is a commercial reservation, where a contracting state applies the convention only to commercial matters. South Africa, just as an aside, adopted the convention in 1976 without reservation. Most of the Asian countries have adopted the convention, but with reservations. So turning now to the specific countries, Indonesia, it acceded to the convention in 1981, subject to both the reservations, commercial and reciprocity. Now, the arbitration law of Indonesia gives examples of activities that are categorized as commercial. And these are the obvious ones, such as trade, banking, finance, investment, industry, and intellectual property rights. Now, Indonesia has not adopted the UNCITRAL model law, but implements the convention through its law number 30 of 1999 on arbitration. And it provides simply for the enforcement of the treaty provisions subject to those conditions. And this means that an Indonesian court will enforce an AFSA award and, of course, other foreign awards if the conditions of the convention are met. The procedure to enforce an AFSA award in Indonesia is fairly straightforward. It is simply to submit a written application to the Central Jakarta District Court, to which an original or certified copy of the award and the agreement are attached. The AFSA award would have to be translated into the Indonesian language in accordance with Article 4 of the convention. So there are three general stages for enforcement of foreign arbitral awards in Indonesia, and the first is registration. And here the award is submitted for registration, and the court issues a deed of registration, which leads to the next step, which is the granting of an exequatur, which is really an authority to enforce. And here the chairman of the court reviews the application, obviously taking into account the conditions of the convention and the supporting documents, and decides whether to issue an exequatur. And the third stage is the enforcement itself. and the party seeking enforcement will have to submit an application for enforcement of the award, and the chairman of the court will issue a writ of execution. There has been a steadily increasing trend of enforcement in Indonesia, and losing parties now rarely succeed in resisting enforcement or seeking annulment. And this is despite the arbitration law providing a very broad discretionary grounds upon which courts may refuse to enforce or annul an award. These statistics show that between 2000 and 2018, the number of arbitral awards, foreign arbitral awards enforced, increased on average by 10 cases per year. And most of these cases come from a variety of institutions, mostly from the Singapore International Arbitration Center, followed by the Indian Council of Arbitration, and then followed by the ICC. Now, most of the cases are defended on the basis of public policy or public order, as it is called there. And the definition is very broad and is left largely to the discretion of the enforcing judge. The law provides, and I'm going to quote, an exequatur will not be granted if the foreign award clearly contradicts the fundamental norms of the whole legal system and the community in Indonesia. And of course, this is fertile ground for defense. But it's encouraging, however, that very few arbitral awards have been defeated on the public policy ground. And where the defense has succeeded, it is where there are parallel proceedings in Indonesia on substantially the same matter. And a recent a decision of the Jakarta District Court held that enforcing a foreign award would breach public policy if it related to litigation about the contract under which arbitration had taken place and had not been finally resolved in Indonesia. So it's pretty much like our South African lis pendens plea. And now turning to Southeast Asia generally, as I mentioned earlier, most Southeast Asian countries are party to the convention, and these include Singapore, Malaysia, Thailand, Vietnam, and Philippines. And they will recognize and enforce AFSA awards if the conditions of the convention are met. And most of those countries have adopted or applied one or both of the reservations. And now going beyond Southeast Asia, China and India are interesting examples that deserve mention. China applies the convention subject to both the reciprocity and commercial reservations. And generally, Chinese courts will enforce foreign arbitral awards under the conditions of the convention, but the process, the procedure itself is quite complex. It starts by application to the Intermediate People's Court. And technically, recognition, the concepts of recognition and enforcement are dealt with separately. Recognition proceedings are heard by the civil division of the Intermediate People's Court, and if recognized, the enforcement division of that court will handle the enforcement aspect. Now, the laws provide for a complex reporting and supervision procedure by the courts, almost a peer review type process. And under this process, if an intermediate court is inclined to refuse recognition or enforcement, it is required to report to the People's High Court for further review. And if that court has the same inclination, the case must be submitted to the Supreme People's Court of China for final review before refusal can be issued, which shows an interest really in enforcing. There's a process. The courts have to be satisfied that it is not subject to enforcement. So the complexity of the procedure has given rise to a perception that Chinese courts are not arbitration friendly and tend not to enforce foreign awards. But the statistics, interestingly, suggest that this is not the case. Between 2001 and 2022, there were 243 cases involving recognition and enforcement of foreign awards. And of these, only 43 cases were rejected on solid grounds, mainly due to procedural defects and invalid arbitration agreements. India adopted the convention with both the commercial and reciprocity reservations. And an interesting feature is that Indian domestic law narrows the reciprocity reservation by requiring that the foreign country, which is also party to the convention, has to be designated under India's official gazette as being a country to which the New York Convention applies. And only 47 of the countries party to the New York Convention have been designated in the official gazette as countries to which it applies. So it is also unclear what exactly the requirements are for notification. So that seems to be the only party to the convention in India where there are likely to be great difficulties. So in conclusion, and very encouragingly, there is a generally growing trend to enforce foreign arbitral awards in Indonesia, Asia, Southeast Asia, and beyond generally, and a party armed with an AFSA award stands a good chance that it will be enforced if it meets the requirements of the New York Convention. Thank you.
Thank you, Roger, for that submission. And at this point in time, what I would like to do is to look at the opportunities that are available for practitioners in both arbitration and mediation sphere. And for that, I would like to call upon Patrick Lane once again to address us on potential opportunities that we have or that are there in this regard. Thank you, Pat.
Yes, thank you again, Ghandi. Excuse me. I want to pick up on a theme which Roger has eloquently spoken about, and that is the importance of enforceability. That is a very significant feature as far as the choice and listing of panelists as far as AFSA is concerned. It is absent the quality of the panel and absent the enforceability of awards, the reputation of any arbitral institution will fail. So one is careful, and I will explain the process which we go through in the choice of panel. In my introduction, I told you that at this point in time, we have a panel of 150 arbitrators from 30 different countries. These include America, China, Europe, Australia, South Africa, Botswana, and the SADC countries. I'm not going to list them all. But in order to ensure that the panelists, and we have, it is an open to anybody to apply to become a panelist. We have looked at other institutions to see how best to qualify and ensure questions of enforceability, form, process, and the like are dealt with. There is a discretion which vests in the AFSA as to the manner in which these applications will be dealt with. But as a rule, we follow a very similar path to the appointment to panels as Singapore does. In other words, the submission of redacted awards, a consideration of the redacted awards by a panel of the International Committee, and if they meet the basic requirements of enforceability, and there is an adequate history of participation in international arbitrations and a knowledge of the rules, generally we welcome the appointment of international panelists from across the world. And I would mention in that regard that the principle of independence and non-domicile of arbitrators is carried forward into the rules. Unless the parties agree otherwise, the arbitrators appointed will be a non-domicile party of either participant in the arbitration. So consequently, the appointments of arbitrators from foreign countries is welcomed, and we welcome any applications for anybody who can qualify. I have picked up a few questions, and perhaps I can answer those in advance. There is no age limit to the statutory age limit to the appointment of arbitrators. But of course, I think the general rule is that you need the necessary experience, which comes with the wisdom of time. So consequently, whilst there is no statutory interference, a good consideration will be the experience and age of the applicants to be listed as part of the panel. Are there various routes? Yes, of course, there are various routes. If one doesn't, experience is one of them. The redacted awards, qualifications such as the Chartered Institute of Arbitrators fellowship, and that type of qualification will be of assistance. And one tries to be proactive in one's response. Sorry, I'm afraid we're picking up an echo. That's better. That one tries, as I was saying, to be proactive. But I think to simply describe the bottom line, we will ensure enforceability of the awards. We will monitor our panelists, not in the same way as the ICC monitor their panelists. We do not vet the awards, but that does not mean that we do not take cognizance of the awards that are being published, which are published through the Secretariat. That the panel is an open panel to international arbitrators, both civil and common law, from civil and common law countries. And depending on the experience, the view of the redacted, the awards, the form of the awards, and an assessment of their capacity and ability as an international arbitrator, they would be welcomed onto our panel. Thank you.
Thank you, Pat, for that. And I think at this point in time, what I'd like to do is to give an opportunity to Dr. Sabela Goel to introduce the Indonesian Dispute Board and also to make the preliminary input into the submissions that have been made so far, and thereafter we'll open the session for questions and answers. Dr. Sabela Goya, if you have any comments, thank you.
I'll talk. How did you spell his name? Sabela.
Sabela Gayo.
Gayo.
Spell it for me, please.
Sabela, S-A-B-E-L-A. The surname Gayo, G-A-Y-O.
Yeah. So he can't talk, he's just a participant.
Participants are supposed to ask questions.
No, we can only ask questions.
We have questions.
We've answered the questions already.
All right, okay, so he can't talk, you say?
He can't talk, he's a delegate, he's not a panelist. Any panelist can talk.
Oh, okay. All right, in that respect, then what I would like to do then is for us to start answering the questions. Can you, Svetlana, help us with the questions so that the panel members can then respond to them because I can't see them from my side.
How to enforce arbitral awards from Indonesia in South Africa is the first question. Yes.
I think, yeah,
I'm afraid, Svetlana, I didn't hear the question. Can you just repeat it?
Enforce arbitral awards from Indonesia in South Africa.
If I may answer that, yes, very definitely so. We are subject to the New York Convention, as I mentioned, without reservation. So if the conditions for enforcement are met, our courts are obliged to recognize and enforce an award from Indonesia.
The next question is there any chance for external arbitrators out of panel of arbitrators to be appointed by AFSA?
Perhaps I can attempt to answer that. I'm not quite clear as to what the question means. Perhaps I could try and get some clarity. AFSA has a panel. It's not a published panel of arbitrators. We have chosen at this point in time not to publish a panel. AFSA will not appoint persons outside the panel in a situation where they are the sole appointing authority. Where, however, the agreement to arbitrate provides for the parties' appointment of a nominated arbitrator, unless there are serious reasons not to sanction the appointment of that person as an arbitrator, the AFSA will sanction and appoint that person as a member of that tribunal, in the same way as if the agreement requires that the nominated arbitrators appoint a president or chair, again, unless there are serious reasons for the non-appointment of that person as president and chair of a tribunal, they will be appointed.
The next question, thank you, Patrick. The next question is, do you AFSA recognize third-party funding for arbitration proceedings? Jonathan?
Patrick, yeah, I'm happy to answer that one.
Yeah.
So the recognition of third-party funding is not necessarily for AFSA to do. Your first question is third-party funding lawful in the country? So in terms of national law, are there any prohibitions to third-party funding? In South Africa, there currently isn't any prohibition. There's also no regulation on the third-party funding. The only thing that AFSA does is, in accordance with its rules, there is an obligation on the parties to disclose the existence of third-party funding and then the nature of the funder. And as I mentioned earlier, that is for conflicts of interest purposes. And so there is no prohibition or restriction on third-party funding. And again, it's not for AFSA to police that. That would be national law or regulation if it existed, which it doesn't in South Africa.
Thank you. And the last question, because we're out of the time, is there any form of dispute resolution cooperation that has been resolved in South Africa, specifically by AFSA, relating to trade practices carried out by Indonesian government? Please, Adv Kuper, could you address that?
Could I get some clarification from the question?
The question is there any dispute that has been resolved under AFSA administration that relates to Indonesian government?
I'm not aware of any dispute emanating from the Indonesian government having been referred to AFSA, and I can speak for the position that the AFSA head office, and I'm sure that the answer is no. There has not been.
Thank you very much. And what minimum age to be able an arbitrator based on South Africa Arbitration Act? Because in Indonesia, according to the existing law, minimum age to become An arbitrator is 35 years old with 15 years of experience in the field of arbitration. And I will answer that question. Note, there is no minimum age for for appointment as arbitrator according to South African legislation. So we're so thankful about the interesting questions, which we will address later. But now it's time for the closing remarks. I give our moderator, Ghandi Badela, for the closing remarks.
Yes, thank you very much once again. I would like to call upon Patrick Lane to give us the closing remarks. Thank you.
Again, thank you, Ghandi. And I shall be very quick because I think you've received a lot of information over a very short period of time as an overview of the manner in which AFSA operates. And I just want to highlight a number of aspects which come through from the various addresses by the members of the webinar. I think, first of all, you will understand that AFSA is constantly looking at reviewing its rules and looking to be innovative and certainly at the cutting edge of international rules to make them the most effective from an expedited arbitration point of view. You will also have heard how multifaceted AFSA is from its genesis as a domestic arbitration institution moving into the international world. But one also mustn't forget that it has capacity and does administer adjudications and mediations and has a wide experience in all aspects of dispute resolution processes. Finally, in terms of excellence and ensuring that the panelists are well qualified, but that doesn't exclude international panelists from making application to become a member of the AFSA panel, and we would welcome from Indonesia such applications of those who qualify appropriately to be registered on our panel. Another feature which I think came out again from Des and others is that there is limited court interference with the in terms of the new International Act, which of course follows international trends and is a vital and strong element as far as South Africa is concerned. The significance is since 1994 and the passing of the Constitutional Act, there were a number of challenges in relation to arbitration as constituting whether it is constitutionally valid. The courts have, without exception, in South Africa come out in support of arbitration as an enforceable form of dispute resolution. And finally, you have heard that the process of the publication of awards is on its way and is provided for in the rules. And like the ICC, by virtue of the international and the cross-border effects of the international division of AFSA, it has a ripple effect right through the international community as far as arbitration, much as the ICC awards do in their own publications. And finally, I'd just like to thank everybody for attending and listening to the various speakers, and to thank the speakers for their participation. And I hope has been has given you a good insight into the workings of AFSA and and encouragement, I hope, for further contact between the organizations. Thank you very much.
Thank you very much. We will then adjourn. Thank you.